sorry, back to my video. So they asked her if her cord was cut before or after, and she wasn't really saying anything. She says, I worked that the day before, so she doesn't really remember if it was working. She doesn't really remember if the phone was cut or not. But that's strange. Um, the court asked, I didn't ask the question very well. Was your phone cord cut to your knowledge before you went to bed that night? She said no. So it was to your knowledge cut as a part of the incident? Correct, she says. But then she says she doesn't really remember. So that's strange right there. Okay. Then they go back. He threatened you. You heard his voice. She says, correct, I did. And you say that after he left, you heard at least one other voice in the living room? She's like, I'm not really sure. And then they ask her again, is that yes? And she says, yeah, I guess so. Now the court says, now he told you that your assailant told you that there were two other people in the room. Is that correct? She says, yes, but I'm not quite for sure. But you only heard one voice, right? She says, yes. The only thing that you heard that voice was yes. Right, she says. And you heard apparently shortly after this person left you alone, someone exited your back door and go up the steps. Correct. Now those steps led to where? She says, they're right next to my bedroom window. And where do they go to? They go up to the upstairs apartment. And there's only one apartment upstairs. You heard someone leaving directly using those stairs. She's not quite sure, but then they ask her the question again, and she says yes. And you waited half an hour as commanded, and you never heard anyone else leave? No, I didn't, she says. Could it be that the person who assaulted you was talking to himself, trying to pretend that there was somebody answering his questions? The witness says it could have been, but there was two different voices. Now, the note was written on a pack of cigarettes that has been broken, opened. She said, correct. When you say a pack, you mean a cardboard box that would hold 2021? She says, correct. Did you happen to see what brand it was? It was an off-brand. You mean like a discount brand or something? She says, yeah, so you're not sure? She says, maybe Monarch possibility Monarch, but you're not sure. The witness says, no, I'm not sure. Do you smoke? Yes, I do. What brand do you smoke? Usually Camels. It wasn't Lights? She says, okay, the court says, okay, it wasn't your brand. She says, no. Now, after you went to the door, you got this note, then you immediately looked out your window and saw someone leaving with tattoos. That don't make sense either. I turned my porch on, yes. The person fit the description that you talked about earlier. Yes, she's pointing Mr. Lolo. They ask her again, light or dark blonde hair, so on. She's nodding. Dark hair, she says. But then she says maybe it was light hair, light blonde hair. So now their description are, okay, one, The person said that I'm 27, yes. And gave you his height or whatever, yes. As far as you can tell, was the description of the person given to you in the note? Yes. As much as I could see, yes. Now the court says, now with your assailant coming back into the house, you were awoken. You already had the pillowcase over your head. Now she's saying that she was on her back when the pillowcase came. They asked her, were you able to look at him or any part of his body? No. You never saw his hands? No. You never saw his forehead? No. I believe he was wearing gloves. That wasn't in the beginning. You say it felt like he was wearing gloves now? It's the last day of July, beginning of August. It's freaking humid and hot. It's in the morning. He's wearing gloves? Now you believe he was wearing gloves, not from what you saw, but from what you felt. Correct, she says. Okay, now the court says, now it's important you've been asked by everybody, and I know it's not fun, but I want to go over this again. And especially I want to try to explain this. You indicated that you were forced to have vaginal intercourse, and then you were forced to perform oral sex. Then you indicated, I believe, that you were forced or that he made an attempt to have anal intercourse with you. She says correct. And the court says, and he did, to a small degree at least, enter some part of his body or something into your butt. Is that correct? She says correct. Now, did you come at a time after that he also attempted or in some fashion got more oral sex from you? She said, I believe so. It's a yes or a no. Plain and simple, yes or no. Was that after the attempt as such as it was a anal sex? She says, I believe so, yes, after. It was separate in different episodes. What? This is so messed up. Honest to God. She doesn't even know her correct story. As far as you recall, the first time that he forced you to have oral sex, was there 2 different times that you were made to have oral sex? Or, she says correct. 1, yes. But in the beginning you said 2. You're pretty sure about that? She says yes. You may step down. Thank you very much. Then the court asked for Mr. Petuno. He is the detective there. They ask him. He's sworn in. Blah, blah, blah. He says that he was called August 1st over to Lakeview for sexual assault. At some point, did you locate Mr. Lalone regarding in this event? Yes, August 8th. And where was he staying? In a residence on the city of Greenville. Did you interview him at that time? Yes, he was placed under arrest. For unrelated matter, he was transported to our facility. After giving his Miranda warnings, he did understand and waive his rights and gave a statement. Did he say anything regarding having sexual relationships with the victim? Yes. He said that Thursday or Friday prior to August 1st, which would be the 28th or the 29th, between 12 and 1 o'clock, he observed Miss K mowing the grass. So this is 1 o'clock in the afternoon. He offered her help. She invited him in for a drink, coffee or beer, according to him. One thing led to another, so it was beer. And they wound up in bed having sex. Did you ask him about the day in question? Yes. And what did he tell you about it? He said he did not touch her that day. So between July 31st and August 1st, he did not touch her in that day. He touched her 28th or the 29th. Did he admit being at the apartment complex on that evening? Yes. But he didn't have sex with her on that day. Detective said that is correct. That's all I have. Alright, Miss Tissue says, so it was on Thursday or Friday prior to July 31st that Mr. Lalone indicated he had seen Miss K in the yard. August 1st is when I was called to investigate. Okay, so there's like, where's July 30th? They're missing that day. So it was Thursday or Friday prior to that. Yes, the 28th or 29th. That's when they had sex. On August 1st, which do you understand your investigation to deal with an alleged assault that occurred on the 31st or the early morning of August 1st, early morning hours of 1st? Okay, the first would have been what day of the week? A Monday. So it would have been in the early hours of Monday. Okay, she said she was working Sunday. She came home Sunday night and was sleeping. The detective says, yes, ma'am. August 1st. Did Mr. Lalone indicate that he talked to Miss K prior to that day? The court, prior to which day? The court asked. Prior the day he stated to you, Thursday or Friday, that he had a sex with her. Consensual sex with her. I don't recall if he said he had spoken to her prior to that day. Did you interview anyone else in conjunction with this investigation? Yes, ma'am. Who else? Mr. S, Miss G.R., and Mr. M.M. Which Mr. S did you talk to? Mr. L. Anyone else? I believe her name was PD or KD, something like that, with the hospital. What that someone related to? Miss K employment. Yes, ma'am. When you asked Mr. Lalone if he had sex with her on August 1st, earlier that morning of August 1st, he said to you, I didn't touch her that day. Or was it his response? They said yes. He said he didn't touch her that day at all. Did he know why you were interviewing him when he made that statement? I didn't touch her. They're like, touch her. The attorney says, pardon me? Did he know that you already advised him why you were talking to him when he said, I didn't touch her? Yes. Prior to after I gave him his Miranda rights, he did at first deny anything with her. It was after a while when he said he had consensual sex. So you had already advised him that Miss K was naming him as an assailant in this sexual assault. That's correct. And that he responded, I didn't touch her. That's correct. Okay, did he indicate to you where he had sex with her? On Thursday or Friday? Yeah, in her bedroom. I have nothing further. Redirect, the court says. The other person, the prosecutor, says, no, thank you. They told the detective to step down. They have no further witnesses, Your Honor. Do you intend to present any evidences? No, Your Honor. They have no evidences. Do the parties wish to make an argument? One person says, I will move to bind the case over as a charge, Your Honor. I also ask the court to add counts of knife, vaginal penetration, criminal sexual conduct, first degree, and charge of cutting and taping a telephone line, the 2-year felony in addition to those alleged. Ms. Tissue, Your Honor, only the evidence that my client was even in the area was Miss K description of having seen him from a distance, identified him as having a dark blonde hair and tattoo, which she said in the beginning was dark hair. The only thing that she identified him as doing is standing next to her porch at the time that she received the note. But then she said in the beginning that no one was out there at all. She did not identify him by any visual observes during the description of the assault. She did not identify him in any verbal response or any recognizing his voice or anything in nature. She also, there was testimony that there were 3 individuals, actually 4 individuals, 3 male individuals staying at the apartment. If she claims that whoever was left her apartment and went upstairs, she didn't see who that was. She didn't testify, meaning Miss K did not testify as to who was upstairs to the apartment. It certainly, suppression-wise, at the best, it would have been my client as opposed to either of the Mr. S. Lee or Mr. S. BJ people. Any other individual might have been around. She simply could not and did not identify my client as being in her apartment. Her only description was seeing him standing next to a porch downstairs from her apartment that he was residing in for a so-called month or 2. Based on her testimony, or 3 weeks to a month base, Mr. S. testimony, certainly somewhere he could have been. It was near the porch of the residence he was staying at for the period of time, and there was simply nothing to connect him to these assaults. The court says, I will bind this case over and I will allow the prosecutor to request to add 2 new counts. They didn't even give a shit. They're just like, nope, you're guilty. Because you were there, even though you weren't there, you're guilty. They had no evidence. Under the threat of the knife, she was also robbed $300, so which he has to pay her back. They're saying that there was evidence from his girlfriend that she felt that she had felt in the past that he was checking Miss K out. Okay, any man or woman would be checking somebody out that they think they're hot. That's no flaw. There was evidence from his friend, Mr. S., that the defendant admitted he had placed a note Miss K's door about that time. Miss K indicated that the note was placed on her door, and the note, of course, had to do with indication that Mr. Lalone has been watching her and her children. Okay, first of all, I would have asked Mr. Lalone what he put on there if I was a detective. What the fuck did you put on there? What did you write? Let me see your handwriting. Does it match? And that there was certainly evidence from his own admission with respect to the note. Okay, that's the only thing. I sent her a note. I watched her. I asked her if she wanted help mowing. I fucked her after that. Okay. Together with the tattoos the height of his size, and the hair, and so on, that indicate that he was down there. There was also no additional evidence in that when her assailant, whoever he was, left, she was able to hear him walk upstairs. That don't mean it was him. It could have been anybody else. So they're just making excuses after excuses after excuses. I think that in one of the other reports I have here, that she told the detective first, is that she ran to the landlord's house first, and that him and his wife took her to the hospital. But she says in court that it was her boyfriend. There was more than one evidence that Miss K was having sex with other people besides Mr. Lalone and her so-called boyfriend. One of her statements, she said that she was in a tank top and panties, but when she was on the stand, she said she was wearing long PJs. She was confused about how many blowjobs she gave. Porch area and living room and the porch light confusing. She said in court that she locked up all the windows and doors, but another time she said that the bedrooms and living room windows was open because it was a hot night. But again, she says in one of her statements that she locked up everything. So that's another confusing question right there. She says also she heard the door slamming, but knows one else didn't heard it. She didn't hear it, but she said there was no pictures, no pillowcases, no rope, no nothing. Her now ex-father-in-law is the chief of Greenville. Why wasn't Mr. S called up to the same morning? Why wasn't he called up to testify? They had him. They wanted to have him testify. But he left the state. He left completely Michigan that morning because his brother, Mr. L, said that his brother took off. Also right after William did. So that's a good question too. I feel that we need to redo Mr. Lalone's case and review it. I'm going to tag, if I can, the Attorney General and Macomb County, and I think they need to look at Mr. Lalone's case and review it. And I think he's 100% innocent. Yes, he did put a stupid note on her door. But why did she say that she didn't know Mr. Lalone when she had 3 days before, prior to that, had sex with him? And why didn't the boyfriend at the time and the landlord at the time testify? Why was it only her statement that put him away? No evidence, nothing. Just her word, her say. And because of the judge, it was voting time for Michigan because he was going to be retiring. They needed a new judge. He he blackmailed. I think he did this, and the attorneys and the prosecuting attorney and the district attorney and all those, I think they were money hungry. So that's what I'm going to say, and that's what I'm going to stick to it. So hopefully you guys can watch these videos. Thank you very much. Free William.